Item number 4.
Yes, Mr. Hajar.
Yes, my lord. Then only the fact is that, my lord, this case is vitiated by respondent number 5 because he is not related to Nankra Aking land. But however, it has not been contested in the lower court, my lord. He is not related to this case, Habat M. Shangma, respondent number 5. In the writ petition earlier, he was not there. Subsequently, he come. How it is come, I have no idea. Another question is that in the judgment, only the finding they have found that Zongshan Momin, who is relinquished his nokmaship in favor of Mene and Alipshan Marak, my lord. Same thing they are repeating in almost all the paragraph. And they have not taken into consideration that Zongshan Momin, the order of the Mene Marak and Alipshan Marak was cancelled by order 3/3/1978, my lord. And thereafter, my lord, the Shimran and Shora Nankra Marak was come into the pictures. So, as I have seen, there is not finding in this judgment, my lord. And one more important thing is that what evidence they have taken, not even a whisper that which evidence is saying what. Nothing is there recorded in this judgment. Only they have recorded the report that Zongshan Momin was relinquished is this one. Only that is the thing are here. And as per the finding in this court, paragraph 34, my lord, it is also totally.
Page?
Page is the last page, my lord, 165.
Yes.
Nothing is finding is there. I go through all this order, my lord. Nothing is there. Shall I come from this? I will start, my lord, from page number 160, my lord, para 29 of the judgment. Only repeating the same thing for a High Court matter, this and that. But there is, in fact, there is no finding in the judgment. And judgment has is passed cryptically without considering the relevant fact of the case, my lord. I will go from para 29, page number 160, my lord.
Yes.
Shall I read out, my lord?
Yes, yes.
Another writ petition WPC 29 of the filed by the Shura and Marak and her husband Shimran Momin against the GDC case number Secretary Executive Committee and Srimati Madeline Marak. The High Court by judgment and order oral 23/9/2000 quashed the impugned order dated 1/1/13 and directed the Chief Executive Member GSADC Tura should proceed the Nankra Aking GDC Revenue Appeal number 5 of 2007 according to law. It is also seen from the copy of the judgment that in place of the petitioner, Srimati Shora and Marak and her husband, Srimati Shimran Srimati Rikmani and Marak and being and Moming are substituted by the order dated 27/2004 passed in Miss Case number 189 of 2013, my lord. So when writ petition was pending before this honorable court, 29, the Shura, Nankra, Marak and Shimran was expired. So it has been substituted by the present writ petitioner, my lord, on the order of the court. On perusal of the petition for substitute petition by Rikmani and Marak and others, it is stated as Srimati Shura and Marak, the Nukma Nankra Aking, on 15/5/13 and enclose a death certificate dated at all. Thereafter by a meeting, this is most important, my lord. Thereafter by a meeting held at the residence of Sri Hemrin C.S. Marak dated 6/5/2013, unanimously selected Srimati Rikmani and Marak and her husband Bening Momin as Nukma of Nankra Aking land, etc.
Can you pause for a minute?
Huh?
Can you pause for a minute?
Yes, my lord.
Now say Sora and Marak, the Nokma died on 15/5/2013.
Yes.
And thereafter a meeting was held
Yes.
on 6/5. How can it be?
No.
Is somebody
5. No, before this date, my lord. Here is 6 May, here is 15 May, my lord.
No, you see, as per whatever is written, the meeting was held after the death, isn't it?
Yes, it should be after the death.
So then how come?
It may be some typical mistake, my lord. No,
See, like this maybe and may not be will have a huge bearing.
no, that is maybe the mistake of this 29, my lord. 1 second, my lord.
Today, can you throw any light on this?
Just check it.
Up to page 160.
29.
160, page number 160. I've
Yes.
seen the date. But let me just check with the original copy.
Yeah, original copy, my lord. 29.
This is things become tougher for the court. You see, it's very difficult.
29. Twenty-four, 25, 26, 27, 28, 29.
Where's the mistake?
29, see, 29. Forty-seven, 15/5, and close the death certificate dated 27. 27, yes. 27, my lord.
The original, that's why I said, in the original copy there is nothing wrong.
Will you compare it before with this thing?
This
It's
is
at
not
least
only first time, Lordship. It is 27.
see, you know
27.
your case. This court doesn't know, so it becomes quite difficult.
So matter may become day after tomorrow, my lord. I will any mistake I will check properly, my lord. It is typical mistake. 27/5 or 2013, my lord.
On
Any
the
mistake?
also, instead of 9 years, it is some 29 instead of 23.
No, that is.
That's why I said
It
the
looked
record
like
now is,
29.
nothing is wrong. If you go by the record, because he just typed it. There's not only one or two occasions that he has made a mistake. There's even the
Only the
participant
date,
also is
my lord.
correctly reflected in the original order. It is correct, but only in his type copy. Now also 27. He is reading. He has typed it 6.
So what is to be done? What is to be done? Writ petition be dismissed on this ground.
No, what I'm saying is, how can it be? Because this is a very serious issue.
Definitely.
Can it be accepted? This is defective.
See, it has to be corrected.
It's amount to be misleading the court.
See,
But it is in the original copy, it is there. There may be some clerical mistake or typing mistake, my lord. So it may become tomorrow or after tomorrow. I will just rectify this date only, my lord. Only the date. Problem with the date.
date, the names, everything you just see. This will be.
Correct. And my lord, the matter is pertinent to Nokma Sheikh. I understand, my lord, and I will submit on this line also.
27th.
Only on the law point, my lord, this matter can be decided without going into the judgments.
What are those points?
Only one point, my lord. What is the right of a substitute husband and substitute wife? This is not by reading the judgment, my lord.
That is an admitted position, that is substituted.
Yes, it is an admitted position. They are admitting in their writ. Second thing, my lord, he is saying that these are the problems which the order was passed, and these are the problems with the order. But where is the pleading in the writ petition? That these are the defects in the judgment. That is why I am before this honorable court. My lord cannot go beyond the pleading.
Normally you should not, but then in the jurisdiction.
Yes,
may
it can. Yes, but my lord, again, if my lord goes beyond the pleading, my lord, then I have nothing to submit on that point on affidavit.
Let not go and take facts into consideration which you do not have a chance to reply.
My lord, it is very clear-cut case where, my lord, a lady, now for example, if my lord may kindly come to page 19, my lord, annexure 1. Sindrai Sangma. My lord may kindly see from the bottom, 4th, my lord. From the bottom.
Sindrai Sangma.
Sindrai Sangma. He's a man.
Not man, it is a Nukma, my lord.
The male and female I am trying to explain. My learned friend may not be in a position to understand what I am saying.
Yes, yes.
So please let me submit.
Yes, submit.
Now my lord may kindly see who was the wife of Sindrai is Jemsi.
Yes.
Out of their wedlock, my lord, there was one issue, one daughter. Now when Sindrai died, my lord, a substitute husband was given.
Johnson.
To Jemsa. Who is the substitute husband is Jongseng Momin. The substitute husband is not a biological husband, my lord. It is only for filling up the post.
Cannot be a biological.
It cannot be. No.
Well, you are making a submission before court.
Oh, my lord, yes. No, I'm just putting my point, my lord. Now, my lord, Jongsang Momin was given the daughter of the previous Nokma. Daughter
of the previous Nokma means
Sindrai and Jengsi.
Okay.
The daughter. There was only one issue. And she should have become the Nokma. She was given as the Nokma because she married Jongsang Momin. But she eloped. The moment you elope, my lord, with some other man, and you are not in the house of the Nokma, you relinquish your right. Now, my lord, Jongsang Momin he said that he was given a wife. Where is the evidence to that effect? They are denying. They are the Maharis. They say, no, we have not given. Now, he said that I was given a wife. Now, even if taking into consideration that the wife was given, my lord, she will be a substitute wife. Because initially it was Jemsi who was the wife of Jongsang. Now, my lord, what is the right of the substitute? Okay, taking into consideration the entire facts, my lord, for argument's sake. Now, the husband becomes the substituted husband and the wife becomes the substituted wife. Now, what right they have? It has been decided by the division bench of this honorable court. What is the right of the substituted husband and wife? The moment, my lord, even if they have an issue, my lord, they will not enjoy the office. After their death, their issues will not enjoy the office. It has to be reverted back to the original Nokma. Now, who was the original Nokma?
Sindrai.
No, my lord. It was Jemsi.
Jemsi.
Now, Jemsi doesn't have any issue because one lady was there, daughter, she eloped. Who remains there is Many is the sister of Jemsi. It has to go to the original Lokma, family member.
So that being view of the matter,
Yes,
the impugned judgment suffers from no illegality.
Yes, my lord. This is the legal position, my lord.
Now,
So if my learned senior want to correct it, let them correct. We'll place the appropriate laws, my lord, before this honorable court.
now, if it is so, my lord, they are telling that Mane is the sister of Jamse. Even Rane is also the sister of Jamse. And if it is, they have got no right that the learned district council court pass an order on 3/3/1978, my lord. They are telling Jongshan Momin has got no right, he is relinquished. So Alipshan Marak and this one become Rokma, which has been challenged by the Jongshan Momin. And 3rd March 1978, order has been passed. The appointment of Alipshan Marak and Mane Marak was sanitized. Thereafter, they have continued for about 30 years without any hindrance.
Junction.
Yes, my lord. Without any hindrance, my lord. Then, against the order of 3rd March 1978, Alipshan Marak and his wife Mane Marak filed a writ of appeal before the Guwahati High Court of Bite number 93.
Is it stated here somewhere? Is it?
It is here, my lord, in the writ petition itself.
The petition is there.
Yes. The page number 21, type copy, my lord.
No, there is the order that my learned friend is trying to tell about the withdrawal order.
Here. This order has been challenged by this Alipshan, my lord, and his wife. And it has been this order, 5th March 1992, Learned Counsel for the petitioner submit that the petitioner do not desire to press this petition, it is dismissed accordingly, my lord.
Yes.
Yes, in 92, my lord. Now, thereafter, my lord, their order was cancelled. Hereafter, this Jongshan Momin, my lord. Then coming Simran Tish Momin and the Surah.
Jamse died when?
Jensen, my lord, we have to check the record when she died.
This withdrawal of writ petition.
Sorry, my lord.
The withdrawal of this page 20.
Yes.
Which Mr. Hazarika was referring.
Yes, yes.
There is 5392.
Jemse, yes, 92.
At that point of time, whether Jamse was alive?
No, my lord. No. Jamse was not there. Jamse was not there, my lord. A date I may not know, but it is confirmed. Jamse was not there. He has died. When on 3rd March 1978, Jongshan Momin became the Rokma, my lord. He was not there. He was died. We period to 1978, my lord. Exact, I have
Then
no idea for it.
Jongshan became Nokma by virtue of his marriage with,
Yes,
Jamse.
second. Yes, yes.
isn't it?
No, here, my lord, yes. But what happened?
Sindrai
Yes,
died.
yes,
Jongshan came into picture, isn't it?
yes. This Jamse
He
missing.
married Jamse, isn't it?
Yes, as a substitute wife. That after his death, his previous husband daughter was given to Jongshan Momin Ringbe. He was eloped with somebody else. Then this clan people has given another substitute wife to Jongshan Momin, Rane and Marak. So Rane and Marak become the Nokma continuously. And after that, Alipshan Marak, this become the Nokma, which has been challenged by the Jongshan Momin and Rane Marak in the district council court. And the appointment of Alipshan and Mane Marak was set aside.
Whether these facts are discernible from this thing, the writ petition will get those facts
My lord, which?
about their.
With a document, my lord, this
Rane. Rane Marak come into picture.
Yes, that is not there here, isn't it?
But
No, Rane name is not even entered.
no,
How he can
it is-
claim that?
No. I am coming to that point.
That patient, will come.
So I am coming to that point, my lord. In my synopsis, kindly may come in page number 136, my lord.
Now this court is getting more confused. Yes, 136 is what?
Yes. 26.
This is the High Court's order.
Yes, my lord. It has been mentioned here, my lord, in paragraph 4. Sorry, my lord. Oh, sorry, my lord, I am extremely beg a pardon,
not
my
there,
lord.
it is not
It is in page number 86, my lord. 86, my lord. Eighty-six, page number 87, my lord. Para 2, I will start, my lord. Para 2, I will start, my lord. Para 2, 3 and 4, it is mentioned.
You are mentioning about some substitution.
Yes, my lord. It is mentioned.
Read out, my lord. My lord, may kindly come to page 87 of the synopsis.
Yes.
The aforesaid person, if my lord kindly come to para 2 and then subpara 2, my lord.
And it is coming into.
Page 87
Page
It is
87
there.
of the synopsis.
Yes,
of
my
the
lord.
synopsis. There is an order of the High Court, my lord,
Yes.
Yes.
where it is written the aforesaid person were appointed as a Nokma.
From where you are reading?
Where are you reading? The paragraph?
No.
Just below paragraph 2, my lord, is subpara.
Oh,
There is no subpara after paragraph.
yes.
No. There is paragraph 2. Start with paragraph 2. Heard Mr. S. Sen, learned counsel for the petitioner. This is
This is
para 1.
first paragraph.
Yeah, second paragraph, my lord, may kindly see.
Second is number 2. Number
Number
2
two.
numbering is there. Yes.
Yeah, then after 2 is next para, my lord, subpara.
Yes.
Continue. And my lord, may kindly find page.
Not subpara. This is number 3. A convenient.
Oh, my lord, it's sealed, so cannot see also. 3, my lord. 3, 6, line 6, my lord. The aforesaid person who were appointed as a Nokma.
Yes.
Yes. Were appointed as a Nokma as the predecessor of the present respondent number 1 against the aforesaid order dated so and so passed by the executive member 1 Jongseng Momin and his wife so and so filed Miss Appeal so and so before the learned chief executive member of the district council. Now, my lord, this is an application file. Where is the entry made in the GT, my lord? Any order is passed, my lord, appointing any person, my lord, there will be a name reflected in the GT. Her name is not even reflected. I can file a petition tomorrow, my lord, and I can say that I am the Nokma. But where is my name in recorded officially?
So I am coming to that point, my lord.
You are correct, Mr. Thing.
Yes.
See, it is useless going here, there.
Half of the day, my lord, yes, sir.
No. Time will go, my lord, because it is not available, because some mistake for that mistakes, for that reason.
Normally, see, especially in a writ proceeding,
Yes.
we have very limited scope
Yes.
for judicial review.
Yes, my lord.
Now you have to project before us that the finding recorded,
Yes, my lord.
either there is non-adherence to procedures,
Yes.
or else that the finding recorded
Yes.
in the impugned judgment is not borne out of record
Yes, my lord.
or contrary to record.
Yes, my lord.
That is a limited thing.
Okay, only for this much.
We may not go
Because-
into all those things, you see.
Yes.
The entire merits we cannot really appreciate.
Yes, my lord. Only the main thing we are pointing out, my lord, how the thing is coming into conclusion. Because in the judgment nothing is there. What evidence telling this and that? Only the regarding junction momin.
No, you said he has taken into consideration report of a Mojadar.
Yes, yes. Now it is there, my lord. In the order it was there.
Then if that is taken into consideration, so it is not a case that is finding without any materials on record.
No, no.
Materials on record is there.
No, no. That Mojida report was set aside, my lord. Set aside by the
It was not in existence of the day on which the court took.
Yes, yes, yes.
Notice of that.
Before
I'm really confused, my lord.
1970.
I'm really confused. First, my lord, the learned senior has submitted that I was not heard. It is very serious because on that ground only my lord can set aside that order and remand it back. He has participated. He filed an application. His facts are saying something else, my lord. He's pleading something else. He's arguing something else, my lord.
That is okay. That is one aspect of the matter. So his contention that he was not hard, he may not stand.
May not stand,
Other
my lord.
contentions.
Other contention, well, but we have to be very clear what we need to reply.
No, here is
So
disputed
he may
question.
have 2-3 points. You will have a chance to reply all the points. You see, non-affording an opportunity is one of the ground. And then what he says, that the report, basing on which this order has been passed,
Yes, my lord.
that order was not in existence, the report, because it was interfered.
Sorry, my lord.
The report of the Mojadar,
Uh-huh.
which was taken note by the
CEM.
CAM while passing the impugned order, he based his finding on that also.
Yes, yes.
Now, according to him, if he says that report stood interfered, it was no more in existence, then in such a case, finding recorded by the CEM, basing on that also will not stand.
Correct, my lord. Correct.
So his contention is that
Whether he is really sure that report was not there. For that, my lord, record has to be called.
report is there, but then this report was interfered with. That is what he says.
Interfered by?
The
That
court,
he will say.
the district council court.
Which court has set aside this report? Whether that report was under challenge?
No, that is during that relevant period of time, it was challenged.
No, but then you said it was set aside.
Yes, my lord.
By whom?
By this CM, Chief Executive Member.
And that order remained. It was not challenged any further. So
With that order, my lord,
where is that order?
that is reflected in the writ petition, my lord, which I have page number 87, my lord. It is not in my possession, my lord. And even
So,
this,
if you say something, then what basis we will?
no, this
No,
is,
okay, fine. Okay, fine. For argument's sake, let us see the pleading of my learned senior, where he has pleaded this point. Where is the pleading? You take us to the pleading that Mozilla report was set aside.
I am not telling Mojida report, but with that they are making on the basis of Mojida report or some statement they have submitted, and the name of the Alipshan Marak and the Mene Marak was registered as a Nokma, which was challenged. They have challenged with that order, with that document, my lord, and which was denied by the junction moment later on, my lord. And it was set aside, their appointment. Otherwise, how it will come?
Is it which order, which document is set aside? That is only saying that this order is set aside, that order. But which order, which date?
No, date is there, my lord. This is there.
Let
Yes.
us
No,
let
no.
us have a
I will show the court,
In
my
the
lord.
withdrawal, in the order dated 23 CM already discussed.
my lord. Let us have a
Yeah,
full
first
argument.
half it seemed that the court is getting some facts. Now it has become more confused.
Yes.
Let us have a full-length hearing, my lord, on this matter, because this matter is also very long pending.
There has to be full-length hearing. You see, like the court is trying to get the facts just in order to appreciate
Yes, correct.
Yes.
the
Now,
facts recorded in the.
certain submission which has been made by Malana Senior is about certain records of Mozilla reports and all this and that. These are not in the pleading, and we have not even.
No, it is reflected in the judgment, my lord.
No, in your writ petition, have you taken it as ground?
Yes, my lord.
Well, let us see. I'm shocked to hear this from my learned senior, and he is not.
He is trying to develop it.
No. Now even that Bojeda report I am not challenging. It has challenged with that document. I mean to say that with that document, Alipshan Marak and Mane Marak able to become the Nukma, which has been challenged. Which has been challenged.
No, whether that report was set aside or not, that is the main thing.
Yes, the report means their appointment was set aside.
Talk about the report, you see.
We're talking about report, and he is saying about the appointment. He is trying to take.
No, here, my lord, that appointment was set aside, my lord.
Now, my lord, he cannot blow hot and cold at the same time. Initially, he said my lord, the report was set aside by CEM.
No.
And now he is saying the appointment. Intentionally, he is misleading this all.
No, it is not like that, my lord. By virtue of this argument, my lord, on the basis of Mojeda report and some relinquishment document, appointment of Alipshan Marak and Mane Marak was appointed by the district council, my lord. Thereafter, my lord, when Jongshan Momin and Rane Marak came to know that,
They challenge it.
it has challenged.
And then appointment of Alipson was set aside.
Set aside.
So it will mean moment Alipson appointment set aside, that report also goes.
Yes.
That is what you want to like to go.
Yes, my lord. Then,
But then the same report
no, after
has
that.
been taken into consideration by the CEM while passing the MP.
Yes, my lord. That is, I am not in my knowledge, my lord. No, that this is was set aside. That they are telling that making stress on the point that as per the Mojeda report, he is relinquished his post. This previous predecessor in the office, they have wrongly.
So in that,
passed this on.
while this appointment was interfered
Yes.
with,
Yes.
was it held that that report is wrong?
No, otherwise it will not be
Was
set
there a
aside.
finding
Yes.
that what was his name?
Johnson.
Junction has never relinquished his right.
Yes.
Is there a finding like that?
Yes, in the judgment and order, my lord, it is mentioned. Judgment and
Judgment order.
This is the impugned judgment and order, it was mentioned.
You are not getting perhaps the.
No,
Let him argue, my lord. It will be very confusing. Every day the facts change without changing
it
the
is not
pleading
changing.
in the main case.
that is their allegation, my lord.
Is it
No,
no,
mainly I will go for the judgment, my lord. I am making this argument, my lord, so it may be come tomorrow or day after tomorrow. So
No,
that
you have to correct those things. You have to see this entire.
Yes.
There appears to be some more mistakes.
Mistake on only the date, my lord. Other thing is okay.
This date is very vital.
Very important. Yes, my lord.
And without correcting those,
It
my
is
lord,
admitted,
it will
my
not be
lord.
proper also to
That
hear
is,
the matter.
But then, Mr. Day, how long will spend with this thing?
That is what, my lord. He has to fix his
Coming
mind
to
what he
any
want to argue, my
finding.
lord.
Rather, things are becoming more confusing. You see, like you do one thing. Please correct this type copy
yes, my lord.
and confine your submission to these impugned things.
Yes,
You read it and
Yes.
say which part
Only
is wrong
I
and why it is wrong.
confined to my impugned order, my lord.
There is no use going into
Yes, my
here,
lord.
there,
Yes,
and all those.
yes, my lord. Okay, my lord. Yes. Only I will correct the date, my lord. The which is most
Heard
important.
the learned counsels for the parties at some time. At the hearing, it appears that the typed copy of the impugned judgment appended to the writ petition has number of typographical error. Stop. Mr. Hajarika, learned counsel for the petition, please. That he may be allowed to correct those mistakes. Mr. Day appearing, Mr. Day and Mr. Sangma appearing for the respondents of no objection. Accordingly, list this matter after a week.
It'll be after 2 weeks, my lord. We'll also let him file it within 1 week. Supply to us a copy, my lord.
I will correct it only. Only correction I will make.
How we will correct it? If you cannot do it by correcting fluid sample. First you find out what are the mistakes.
Yes, my lord. I will find out and then.
You correct it accordingly.
Yes, my lord.
Correct copy, let him supply the correct copy to us, and then after a week it can come.
Yes, judgment I will correct copy if required. I will supply to them.
So make it 2 weeks then. You will correct it. What is it? According to list matter. After 2 weeks, okay. Meanwhile, Mr. Hajarika shall take all the steps for correction of the. Anyway, it's already there. It's not needed. This is
One copy I will supply to the court.
time you see.
One copy I will supply. Corrected one I will supply to the
You just do it. You see, it should be at least there should be coordination between you.
Yes,
So far as those small things are concerned.
Yes, ma'am.
Item 11.
Much.
I'm praying for 4 weeks time.
Why?
The conducting council is not keeping well, my lord.
No objection, Your Lordship.
What is this matter about?
482, my lord.
For?
An FIR was lodged, my lord.
For quashing, seeking FIR.
Yes.
Under what section of law? FIR was lodged under what section of law?
153A, my lord. A video was uploaded on YouTube, my lord. That was prior 6 months before the lodging of the FIR. And respondent number 3, on the basis of the video, my lord, he has lodged an FIR stating that the video might bring some conflict between two communities.
Inciting communal disharmony.
My lord.
Anyone appearing for private respondent?
Lordship, I'm appearing. I filed my affidavit.
You have filed your affidavit.
Yes, my lord. We have received it.
Straight ahead, file any objection or not prepared.
No, Your Lordship.
We will not be filing.
No, Your Lordship. Mr. Shulai will be arguing, Your Lordship.
Okay, on the prayer of the learned counsel for the petitioner, list this matter after
4 weeks, my lord.
4 weeks.
2 weeks?
It's up to you. If you decide to take it up, we will have it out to you. But it's use of, you see, like renewing the prayer again and again.
Let it be 3 weeks, Your Lordship. 4 weeks might be
Because
too
at
long.
least 4 weeks, I think it's quite long. That this is a small matter.
Okay, 3 weeks. Make it 3
Fine.
weeks.
Obligation.
Advised, Your Lordship.